access to the courts is a well-established right of the press and the public, and for very good reasons, which really need very little explanation. The only remaining issue in Vermont is how quickly these documents need to be made available.
I'm Justin Silverman of the New England First Amendment Coalition. If you haven't already, please visit NEFAC.org and register for our classes on state public record laws and the Federal Freedom of Information Act. We've partnered with the Society of Professional Journalists to offer these classes to you every Wednesday, beginning next week and running into July. They'll be moderated by NEFAC's Emily Sweeney, a reporter at the Boston Globe, and they'll feature many of the region's leading open government experts and attorneys. So, want to know how to file a public records request? Need to know how to appeal a denial? Just curious about what type of government information you're entitled to? Visit NEFAC.org to register. I'm here today with Robert Hemley, an attorney at Gabel and Shea in Burlington, Vermont. Robert is representing NEFAC and several other media organizations in a lawsuit against state and county court officials over access to judicial records. Robert, thanks for joining us.
You're welcome.
Robert, what is this lawsuit all about? What are the arguments being made?
Okay, well, first of all, as you said, NEFAC is one of several plaintiffs in Vermont which have combined to bring an action against the state of Vermont, essentially against the clerks and the court administrator, in an effort to get more prompt access to newly filed complaints in civil cases. And the theory of the case is one that's well established in the Second Circuit. Vermont is part of the Second Circuit, along with New York and Connecticut. And in a case in New York, recently in federal court, it was well established, or confirmed, I should say, that access to court records is a First Amendment right. With that in mind, Vermont is out of compliance with the right of the press and the public to gain prompt, even immediate access to newly filed complaints. Vermont has taken the position that they first need to review all newly filed complaints for two reasons. First, to determine if there is any confidential information contained within the document, and secondly, to determine if there are any administrative failures that would prevent the acceptance of the suit by the Vermont courts, such as failure to pay the fee or a misnomer somewhere in the caption. Matters that are of no real consequence, frankly, to the press or the public. What's important to the press and the public is that they get access so that they know as soon as possible what lawsuits have been brought. Our position and the position of all of the plaintiffs, which includes most of the major Vermont media, both broadcast and print, along with Courthouse News, which is an organization that aggregates lawsuit information across the country, is that this information needs to be disseminated immediately in order for it to remain newsworthy, especially in a 24-hour news cycle such as we have now. If there is a delay of 24, 48, 72 hours, as is often the case in Vermont, by the time the public learns about the lawsuit or has access to the lawsuit, the information is already somewhat stale, and the news cycle has moved on perhaps to other matters. So it's important to get immediate access. That's what we want. And that is what the court in Vermont, the courts in Vermont are resisting.
And how does this compare to other jurisdictions, Robert? Are other states in New England or across the country dealing with this challenge of getting immediate access to judicial documents, or is this unique to Vermont?
It is not unique to Vermont. There have been lawsuits across the country which have been brought by Courthouse News Service, either by themselves or in combination with local media elsewhere, in an effort to establish this very same principle. And by and large, they have been successful. They are currently in litigation in Maine, which is in the First Circuit, which includes Maine, Massachusetts, and also they've brought lawsuits in California, in Missouri, and elsewhere, establishing the same principle. And they have, by and large, been quite successful, although it hasn't been automatic. There's been resistance almost always on these same bases, that there needs to be a screening first for confidential information and for administrative details. Now, the issue in Vermont about confidential information is, in our view, an unnecessary element, because the lawyers who file lawsuits are required in advance to screen themselves for confidential information and to redact that from any lawsuit. The information that's at issue, or which the state raises as an issue, are things like social security numbers and bank account numbers, almost always excluded from complaints in the first instance because they're not really necessary. And if they are deemed necessary by the filing attorney, then they can easily be redacted without any screening process. So the reason advanced seems unnecessary, and in other courts they have been determined to be unnecessary.
That's good. So these arguments that we're making here in Vermont, these have been argued successfully in other jurisdictions. So we know that courts, at least those outside of Vermont, have taken the First Amendment right to access and these other arguments that we've made into consideration, and have ultimately provided the immediate access that we're looking for here. Is that right?
That's right. By and large, it's not 100%, but it's certainly the majority of courts that have reviewed the issue.
Great. And can you explain for us the First Amendment component of this case? Because I think for many watching this video right now, they're thinking, okay, the First Amendment provides us a lot of freedoms, a lot of protections from government, but it doesn't often give us access to government information. That's why we have state public record laws, for example. That's why we have the Federal Freedom of Information Act. But it's different, right, under the First Amendment when we're dealing with access to the courts, correct?
Yeah, the access to the courts is a well-established right of the press and the public, and for very good reasons, which really need very little explanation. The public needs to know what the judicial branch is doing. When someone chooses to bring a lawsuit, it's not secret, it's not the Star Chamber. It proceeds in the daylight, and everyone has an opportunity to evaluate the behavior of the litigants and the behavior of the judges and the adjudication of these matters. That's not really a matter of dispute, and Vermont has acknowledged that. Vermont has its own set of rules of access to court documents. It's been well established in Vermont for some time, first established by litigation, that court documents are public documents. And then by rule, the only remaining issue in Vermont is how quickly these documents need to be made available.
Yeah, so let's wrap up with that, and particularly for the sake of those that that aren't journalists, don't work in courtrooms, and don't have a lot of experience with the judicial system generally. What's at stake here? What does the general public have to lose if that type of immediate access ultimately isn't provided?
Well, what they lose in some cases might be knowledge to any extent that particular cases have been filed, because the passage of time makes the news stale in some cases and less newsworthy. Whereas if it is provided immediately, it will be reported immediately. It provides the public with the right to react immediately to events that are being undertaken. There will be challenges to environmental matters. You could assume that there could be all sorts of issues of very legitimate public interest that the public wants to know about right away and react to, excuse me, right away. They'd be deprived of that opportunity if they have to wait around, in some cases as long as a week, to even know that a matter of public concern has been raised.
Well, Robert, thank you so much for taking the time to walk us through these legal issues. Best of luck with the case, and fingers crossed for a favorable ruling.
Thank you.